Hey folks, Dale Davidson here today. Thank you for joining me. Hey, did you know that if your claim has been denied and you're past the 1 year period, okay, you can at any time attack that final decision and maybe reverse the VA's denial? Hey, that's what we're talking about today is Q motion. Clear, unmistakable error motions. Now, these are not as easy as it sounds, and it never is with the government, okay? But again, we're talking about Q motions today, and we're talking about the VA, and we're talking about the government. Clear and unmistakable error. So, what is a Q? What is a clear, unmistakable error? If you've got a claim that has been denied in a prior decision, you can file a Q motion with the VA. And if successful, your prior decision is not reopened, it's revised to conform to the true state of the facts or the law that existed at the time of the original claim or your denial. Okay, so it's reversed, it's not reopened. That's a big difference, okay? Just think how powerful the Q is. Your earlier decision is not reopened, but changed, allowing you to receive an earlier effective date. Let me give you an example of that. So, for example, you got a denial back in, let's just pick a year, 1992. And for whatever reason, PTSD or any number of injuries, okay? But the VA really screwed up. I know it's hard to believe that the VA screwed up, but they screwed up and applied the wrong law or did something totally against their rules. Well, you didn't pick up on that, didn't know about that until recently. So what do you do to correct the VA's error? You're way past the 1 year statute, so you file a Q. And if you're successful, your effective date is not today, the day you filed the Q, but all the way back to 1992. That's a lot, and you get back pay for that. And that's a lot of back pay. 32 years worth of back pay. That's a big benefit to the Q. Now, the statutory authority for Q decisions, okay, says that the VA can reverse or revise a prior decision, and it has the same effect, not effect, but effect, as if the decision had been made on the date of the prior decision. So again, we're going all the way back to the original date. In our example, it was 1992. Very important, okay? So, let me give you another example of just how powerful that Q motion can be. So let's say that in 2022, the VA office found clear and unmistakable error, Q, in a 1989 rating decision denying service connection of your lower back disorder. Okay? So the VA would reissue its 1989 rating decision to reflect a grant of service connection, and let's say they award you 20% effective 1989. So you're going to get back pay from the effective date in 1989 to the date of the Q. All right? But wait, let me throw a twist in there. So let's say that the VA learns later that the grant of your service connection was wrong, that they made another error. I know it's kind of hard to believe the VA makes multiple errors. And they say, because your service connection, is that going to be affected by this? Well, in this example, because your service connection had been in force for 10 or more years, the new rating date is 1989, it's not 2022. Okay, your service connection can't be severed and your disability rating can't be reduced absent the VA showing that you committed some kind of fraud or you didn't have the required military service or your character of discharge disqualified you. So let's see, that's 420 months of back pay, and let's say an additional $300 a month, that's about $126,000 in back pay the VA owes you all the way back to 1989. So look how powerful the Q is. But hey, with the good, there's the bad. So don't count your chickens before they're hatched, okay? The use of Q is not necessarily your panacea or your cure-all. And let's talk about, there's some instances where we have stage rating cases. And in 1985, the VA decision terminated a veteran's receipt on a total disability rating based upon individual unemployability. And the court concluded that in 2007, the 2007 decision had the exact same effect as the 1985 decision. They just corrected the effective date, so you didn't get any back pay in that case. You got to be careful. A Q is just not the cure-all all the time. What's the time limit for filing a Q? There isn't any. You can file a Q at any time, decades later, after the VA decision becomes final. So generally you get your decision and you talk about a higher level review or supplemental review or disagreement with the decision. You've got 1 year to file that, okay? And we talk about that in another video. But let's say that you're past the 1 year. You file the Q, okay? If you're not going to file the higher level review or supplemental, okay? So you don't have a time limit to file a Q. But you don't always want to file a Q just because you got denied. There are other alternatives that may be better. You just got to look at your different circumstances. So what do you do when filing your Q? Okay, you submit your Q request to the regional office of the VA that issued you your initial decision. So you seek a revision of the prior Board of Appeals decision based on Q. So you got to file a motion with the Board of Veterans Appeals. Now, it's very difficult to win a Q. Okay, the government doesn't make mistakes. Okay, so what types of errors constitute a Q? Now, the courts and the VA have defined Q in the following manner. In order to establish a Q, you must show that either the facts known at the time of the decision being attacked on the basis of Q were not before the VA, or the law then in effect was incorrectly applied, meaning they didn't follow the law. Okay. Number two, the error occurred based upon the record and the law that existed at that time. And number three, had the error not been made, the outcome would have been manifestly different. Well, if they should have ruled that I had PTSD, and they didn't rule that I had PTSD, so if I'd had PTSD, I'd have gotten all these benefits, but that's just not how it works because it's a process, okay? So again, Q is a very specific and rare kind of error. It's the kind of error of fact or law that when called to the attention of the VA or later reviewers, okay, compels them to conclude that, look, reasonable minds could not have come to a different conclusion, okay? And that the result would have been manifestly different had it not been for the error. So it's got to be a clear error. So generally, either the correct facts as they were known at the time were not before the board, or the statutory and regulatory provisions that existed at the time were incorrectly applied. A Q is based upon the record at the time of the decision, and it's based upon the law that existed when the decision was originally made. As a general rule, you cannot present new evidence for a Q. So they're looking at the evidence as it existed, what was in the file at the time the decision was made. So you can't introduce other medical evidence or any other kind of buddy statements or whatever it may be to kind of bolster the record. But what you can do is make legal argument. You can argue that based upon legal argument, and you'd have to research all this through Board of Appeals decisions and things of that nature, that the facts in the case, you point to specific facts, and you say, based upon the facts were there, but they either ignored those facts. For instance, the fact was there that my doctor at the VA diagnosed me with PTSD, and they totally ignored that, and in the rating decision said, hey, there's no evidence in the record that he had PTSD, despite what the VA's doctor said. Clearly, that's part of the record. Okay? So, again, you can make legal arguments. You can't add additional evidence. So here's some examples of legal arguments that you cannot make to qualify for Q. Well, the VA doctor had a medical diagnosis, and that diagnosis was wrong, and that was relied upon by the VA. Okay, you can't argue that their diagnosis was wrong. Well, the VA had a duty to assist, and they failed to fulfill their duty to assist. Not a Q. Okay. Well, they said that they weighed these facts against these facts, and they said that these facts were more probative or worth more than these facts, and I disagree with that. No, you can't. That's not a Q. Okay? You can't have a Q based upon an interpretation of a statute or regulation. Okay? Well, I know the VA said that statute said this, but according to my interpretation, it actually says that. Not a Q. Okay? So you just got to be careful in your crafting of your Q motion. So what can you do to improve your Q chances? Look to see in your decision, and read it carefully and read it over and over and over. Look to see whether the VA fully and sympathetically developed your pleadings to their fullest, okay? By determining all potential claims related to the evidence that was in your file. The VA has a duty to look at everything and say, well, Dale, you probably don't have PTSD, but you got some other mental things going on. So instead of saying, well, you don't have PTSD, therefore we're just going to ignore the mental part over here, they can't just do that. Okay? They've got to help me develop my claim, given all of the evidence. Okay? So that sounds all well and good. Okay? But you're telling me I need to do some research, I need to develop my claim and all this. I'm not a lawyer. I don't want to hire a lawyer. I don't want to hire you, Dale, to do this for me. So how does an individual do this on his or her own? So let me give you an example. This came from a VA decision. So in June 1994, a veteran submitted a claim for depression secondary to his service connection prostatitis. Okay. Now the VA granted service connection as well as total disability based upon TDIU, total individual unemployability. Okay, and assigned an effective date of June 1994. Now, saying that this is the first time the VA or the veteran had claimed these disabilities. They also said that his mental or psychiatric disorders were secondary to his service connection prostasis. Okay, I think I'm pronouncing that the right way. Anyway, so after the effective date became final, the veteran filed a request to revise the VA's decision based on Q. We're trying to get that earlier effective date, remember? He argued for TDIU, okay, on the ground that his prior benefit claims, combined with the evidence in the record at the time, were sufficient to raise an informal claim for secondary service connection for his psychiatric disorder. Now, the VA said, nah, I don't think so, okay? You got to show evidence, that's beyond debate, okay, that an informal claim for secondary service connection was filed prior to your 1994. Well, the vet said, nah, I don't think so. I think you're wrong. So on appeal, a federal court held that the standard that the VA used was wrong. It reiterated that the VA has a duty to give, and they call it sympathetic reading, to all the potential claims and all of the evidence in a veteran's file, and apply all that to the regulations to see if there's anything there that would help the veteran out. Sounds a lot like duty to assist, okay? Now, they didn't do that, so the VA was reversed on that. So, let me ask you a question. Is it Q to fail to apply applicable regulations, for instance, when the VA fails to follow regulations that govern whether an existing disability rating should be reduced? Okay. Q is tricky. There are a lot of twists and turns, So, how do you file a Q? Okay. Well, basically, you got to draft a pleading. Okay. A pleading is basically just on a piece of paper saying, based Q, and here's my facts, and here's my legal argument. Okay. So if you're represented by a lawyer, they'll know how to do it. Okay. Of course, like most people, you probably are not going to use a lawyer. So if you're not represented by a lawyer, then you don't have to be as specific as if your lawyer represented you. Okay. But you got to let the VA know that you're not represented. Okay. So they're going to give you a break if you're not represented by a lawyer, but only to a certain extent. So be careful. But they don't know that you're not represented if you don't tell them. So if you're not represented by a lawyer, just know that the VA's got to give a sympathetic reading to your filings. Okay. Doesn't have to be detailed, but it's got to be sufficient enough to make sure that the VA knows what you're trying to get at, and let them know that you're not represented by an attorney. Hey folks, thank you for tuning in today. Hey, check out this video, how to increase your VA disability rating, for more information on the disability compensation for veterans. Until next time, have a blessed day.